because Michelle Saunders, Dr. Saunders, who is the person who wrote for a grant with the Geriatric Education Center.
Yes.
Yes. She wrote for this grant, and this program is sponsored by the Bexar County Women's Bar Association Elder Law section. San Antonio Bar Association. That's Bexar County's the women. This is San Antonio Bar Association. I'm sorry, Elder Law section. Well, guys, if it's not written down here, I don't know what it is. And so, no, I'm sorry. Anyway, we're here today to talk to you a little bit about our clients that we see, our elder clients. And I want to thank Dr. Saunders for getting this room for us, and Karen Hogan, who's the president of the San Antonio Bar Association Elder Law section, for getting our sponsorship and CLE for us, 2 hours of continuing legal education for this. Colleen Kennedy, this is Dr. Kennedy. She's going to be talking to us today about the medical end of it, and I'm going to talk to you a little bit about the legal end of am I crazy or just incapacitated?
Okay, good.
And I'm getting good enough sound
without
that
it?
if you're that if you're within 3 feet of each other like this, you don't have to trade it back and forth.
Oh.
I can hear her really well.
Great. Okay.
All right, you wear it. I'll talk loud.
That sounds good. Do you mind if we sit down?
I don't mind at all.
Okay. Okay. Hello, everybody. Okay. Well, we'll start with a case presentation, and then we'll lead into the issues of guardianship versus commitment. And so hopefully everyone has a handout? Yes? Okay, good. Okay. Okay.
And we're going to take questions?
Yes, what we thought we'd do is we'll do the case presentation, and if you have questions about the case afterwards, then we can answer that, and then we'll go into the legal issues of guardianship, and then questions after that as well for both of us. Okay? Okay, great. Okay. Well, this is a 63-year-old female who was transferred from Kerrville from the Sid Peterson Memorial Hospital to the Geriatric unit at the Methodist Transplant and Specialty Hospital for evaluation of dementia and recent outbursts of anger. She'd been admitted to the Sid Peterson approximately 10 days prior to the transfer for a diabetic coma. She had had insulin diagnosed probably 1983 or so, and had 10 days prior to the admission to Kerrville had been non-compliant on her insulin regimen, and according to her husband had been very lethargic, had been in bed 18 hours a day, and had basically refused to take her insulin and refused to take any medication or eat for that matter. So when she finally became unresponsive, her husband called EMS and she was transferred to Kerrville. So after 10 days, her diabetes was better controlled. She was medically quite stable, but the psychiatric issues came to the fore, and that's why she was transferred to San Antonio, which is where her daughter lives as well. So according to the patient, she had no reason to believe that she needed to be in the hospital. She felt that she was fine. She denied any chest pain or shortness of breath, any abdominal pain, denied explicitly any memory problems, and also denied any history of dementia or depression. So the past medical history is remarkable for the diabetes mellitus, which was diagnosed in '83, and again was treated with oral hypoglycemics with the glipizide until '97, when her primary care physician put her on insulin. And according to his notes, he basically said that she had been non-compliant on office visits and on her regimen and on her diet for that matter, for reasons which are really not clear in the notes. But also with the admission to Kerrville, they tried to get her into some diabetic education classes, and she stated that she already knew all that stuff. She didn't need to go through it again, and her husband said the same as well. So pretty much didn't participate. Also, she did have a history of depression, which she denied, but her primary care physician had tried to put her on Zoloft in the past, and she really had refused to take it, stating again she is not depressed. She was quite happy before she was in the hospital. And so also the diagnosis of hypertension and reportedly compliant on that. She did have a thalamic stroke in 2000, and after that the family states that they noted significant memory deficits, and she had deferred finances to her husband after that period. The review of systems is pretty much non-contributory except for a 10-pound weight loss over the last 2 weeks during the hospitalization. Sometimes she'd refuse to eat. And when this was addressed to her, she basically stated that she's always had a fluctuation of 10 to 15 pounds, and she's never found that to be concerning to her. Otherwise, unremarkable review of systems. Social history, this is her second marriage. She's been married for 13 years, and she has 4 children by a previous marriage. And she had been living with her husband in Kerrville prior to the admission. No alcohol history and no tobacco. As far as her functional history, she's very independent in the activities of daily living, and as opposed to her independent activities, she really has not been able to drive for several years because of memory problems, and also her husband's kind of taken over the shopping and such because she was notably very frustrated with the shopping tasks, so she'll go with him, but he'll pick out the meals to buy. And also she is not able to find a phone number in the phone book, but she can dial the number when it's written down for her. Her medications include insulin and also Norvasc for her hypertension. Again, she had been prescribed Zoloft, but she refused to take it, so that really isn't written down on her medication list. Also, she had been prescribed Xanax for anxiety and for these outbursts of agitation, but she's refused to take that as well. Physical exam, she was very agitated. When I first met her, she was very uncooperative with questions. She was kind of suspicious as to who I was and what my intentions were. And so we were able to get past that, and she still would answer just with a paucity of words, either yes or no. She would never elaborate on any of the questions I had for her, and she just kept saying she wanted to go home. So her physical exam was pretty unremarkable. Basically, neurologically, she was very intact, no evidence of any stroke by motor signs or sensory deficits, and speech was intact as well, no tremors, no gait abnormalities. Her lab work was pretty unremarkable except for the glucose, very wide swings from 60 to 300. Even with the intensive monitoring in the hospital, she still would have these swings. And also her hemoglobin A1C, which is a test for control over the last 3 months of diabetes, is elevated at 9, with ideal being between 5 and 6 for diabetic control. And also normal kidney and liver function, normal thyroid function, normal lipid profile as well. The CT of the brain, which was done in Kerrville, showed an old lacunar infarct, which was from hypertension, and it was in the thalamic and the parietal regions. The neuropsych testing, I basically did it rather informally. She really wasn't going to cooperate with any formal tests, so I just used the categories that we look for in neuropsych testing. And it actually took 2, and actually probably more like 3 visits to get this completed, because she really pretty much put an end to it after 10 or 15 minutes and would not participate further in the questions. So we did glean most of this from several visits. I did let her know that this was perhaps going to be part of a guardianship. And so behaviorally, she just kept asking, why does everyone think I'm crazy? She kept asking, where's her husband? And also she kept asking, who brought me here? So she had no recollection of having been sent from Kerrville to San Antonio. Very limited attention span. She was oriented to person, place, and time, and she did understand the reason for my participating in her care. She was not able to really do much in the way of written sequencing. In other words, I would have her do a 3-part task, and she had trouble with that. And also, as far as basic problem solving, I asked her what she would do if she were at home and found her husband unconscious. She said she would call an ambulance, and when I asked her the number, she couldn't tell me the number. But she said she promised me she'd write it down on the phone for the next time. But this is not something she had thought about as far as a safety issue in her home, where she'd lived with her husband for at least 13 years. And as far as judgment, she basically stated that she'd rather go home and die than stay in the hospital, and stated that she's quite capable of taking care of herself. She really did not have any insight into the problems that brought her to the hospital in Kerrville in the first place. She stated that she knew she had diabetes, but she didn't really believe that that brought her into the hospital. Also did not really believe that diet had anything to do with it. Oftentimes she'd eat cake, and then sometimes she wouldn't eat any meals at all. So that really explains a lot of why her insulin regimen was hard to monitor. As far as her academic performance, she really wasn't able to do arithmetic. She basically said, "I've never been good at math." And also, she was able to write a simple sentence, but she didn't really, she wasn't able to perform after that. Speech was quite fluent, although word fluency was impaired. She basically could not come up with more than 2 words that started with the letter A. And also, her language comprehension was intact as far as asking her to do simple things, as far as, getting dressed, going to the cafeteria, that type of thing. But she really didn't grasp any of the complexities, for example, about guardianship issues and that type of thing. Memory was impaired only mildly for remote memory, but for recent events she had no recall, as I mentioned earlier. She also didn't really recall anything that she had learned in any of the diabetic classes at all over the many years of her being a diabetic. Motor skills were intact, sensory was intact, her hearing and speech were fine. She did have trouble with spatial design, such as the clock drawing that hopefully we've all seen before, as far as the check for executive function. And also, I did have to repeat the instructions for the clock drawing several times before she would do it. The mood was dysphoric, again very agitated with being there, and stating that she was very angry with her daughter for having brought this to fruition. She really was upset with the staff and just anybody who was participating in this, stating again that there's nothing wrong with me. She denied again being hopeless or feeling worthless or having any guilt feelings such as depression symptoms would elicit, and also denied being angry, although the nurses had documented in the chart that she had had very verbal and sometimes physical gestures with her daughter during the hospitalization prior to transfer. So here we have a woman who basically is rather young. At 63 isn't very old by many standards, but she's obviously got her problems with her diabetes and hypertension, and also the stroke has complicated the matter. And so the questions are, does this lady need a guardianship, and then who would be the best guardian for that, or would she be more a candidate for commitment? So I will defer that to Patty to discuss.
How many of us have seen clients like this that they're older or maybe not so old, and they don't want to take their medication, they don't want, they become possibly disoriented, they get combative, and is that person a candidate for an involuntary commitment, or is that person a candidate for guardianship, or is that person should they do both, or should you just leave them alone and let them do what they want to do? I mean, what would have happened if this was a 30-year-old as opposed to a 63-year-old person?
Well, that's a good question. Actually, the whole question comes down to if you eliminated the diabetes and if you eliminated the cerebrovascular disease, and this is just a woman who is adamantly against taking medication, she's got that right as an autonomous individual to make bad decisions. But then, and so in a 30-year-old, you would assume that without any prior medical problems that she's basically got that right to make that decision. But then you add those complexities and you have to tease out whether that person truly understands what they're saying, or whether this is because of the stroke that they've had that's in that area of the brain that affects the learning and the recall and the ability to understand a complex issue.
And you met with not only the patient but the family, and there's some conflict between the family.
Yes.
Does the husband get along with the daughter?
Not at all, actually. And again, this is a stepfather, stepdaughter sort of relationship that has been strained, to say the least, before this even happened. And so the issue comes into who actually has the best interest of the patient. In other words, the husband states, "This is my wife. I love her dearly. I want the best for her. I've tried very hard to take care of her." And so, you know, what right does the daughter have to step in? So that comes up quite often. And then the daughter basically feels that because, you know, in her mind, her mother basically was in the hospital because of the husband's refusal to step in and say, "Listen, we're going to the doctor," you know. And so that's really the crux of the whole thing, is the question why the husband did not bring her in sooner. Did he understand the complexities of what was going on? Did he just defer to his wife, who said, "Don't take me in"? And you know, that's kind of where we are with the dynamic of the husband and the daughter. Both, you can see both angles, but you know, there's really a question of the events that led to the hospitalization.
And I'm going to take the position that the daughter has come to see me and has asked me to represent her as her attorney and how am I going to advise her? Are we going? Does does mom need a guardianship? So should we file an application for guardianship, or should we file, or should we see about having mom involuntarily committed? And what's the difference between those two? Because I know that I've had, if a person is being unmanageable or they're doing things that I find irrational, I immediately think guardianship. And in looking through this, often that's not the answer. A person may have capacity, they may just not be taking their medication. They may be having some difficulties working through something. Maybe the medication they're taking is incorrect. They've changed that medication and they're having a reaction to it, but they aren't incapacitated. And the difference, the attorneys here know the difference between incapacity and capacity. With incapacity for a guardianship, it's a person who can't handle their own finances, or they can't take care of providing food, clothing, or shelter for themselves. With a person who's needs an involuntary commitment, that person is a danger to themselves or others. In the paper that I've handed out on the brief reference guide for involuntary commitment and guardianship, what I try to do is just kind of give you a little overview with the code sections so that you can sort of get an idea of what these two programs provide. But I think that in talking with my client, I'm going to try to find out which way do we need to go. Do we need to go in and do a quick temporary guardianship for this person because she's in distress, when maybe she was at home and I'm seeing this, her condition is degrading, and I see my stepfather, who I just can't stand, is not taking care of my mom. Should I do a temporary guardianship to try to get control of mom and get her some treatment? Or is mom incapacitated? Is she being a danger to herself, or not to others? She's not going after daddy with a butcher knife, but she's not managing her diabetes. Right. So should I look at maybe an involuntary commitment in this situation to get her into the hospital and find out and get her back on her meds, get her stabilized in that situation. So my initial meeting with the family is going to be with the daughter, and as you attorneys know, if I'm going to file a guardianship, I'm going to need a doctor's letter. And I've put out for everyone a copy of something. I think probably Karen Hogan is the person who drafted this initially, or someone over in the clerk's office, but this doctor's letter is something that I send out to my doctors in anticipation of a guardianship, because if it's not a temporary, it's not something we have to get done real quickly, mom she's still okay, they're at home, she hasn't cratered yet, but I think she needs a guardianship, and I think Daddy's, my stepfather is not doing a good job, so I'm going to file for guardianship. I need a doctor's letter. So Colleen, I fax this over to you and say, I know you're my mom's doctor. Colleen, will you please fill that out and fax it back to me? And what is, and you've never met me, by the way.
Right.
What is your response to this that you get on, the first thing you see is this thing chunking out on the fax?
Right. Well, the first thing is, I've never met you in my whole life, and I have absolutely no permission from the patient to divulge information. And until she actually has a guardian or an agent, I also, can't even give it to you on any circumstance. Even if she had an agent, that agent would also have to let me give that explicit information to you as an attorney.
What if I sent over to you my doctor's letter along with a copy of my medical power of attorney, and it's now May the 8th, which is a number of days past the HIPAA deadline. And we'll talk a little bit about HIPAA in a minute. And so I fax you my medical power of attorney along with this questionnaire, and I even give you a cover sheet that says, please fill this out and send it back to me.
Right. Still can't do it. No. Well, and also, too, the questions that they're asking are questions that basically, you have to have a pretty accurate assessment of that person's behavior. And what if you saw that person 3 months ago?
But you saw her 3 months ago,
yeah,
Dr. Kennedy.
That's true. But again, it's something that you have to err on the side of being in the best interest of that patient and say, basically, come in and we'll reevaluate at this moment, because a lot could have changed, especially if they have a medical history. If they had a poorly controlled diabetes, had just gone through a stroke, well, they're incapacitated at that moment, but 3 months later, they may be fine. So that's really the problem, is the time frame.
So you're going to be going by and picking up Mom,
yes,
and bringing her over to your office and saying, here's Mom, by the way, here's a questionnaire.
Yes.
While you're examining Mom, fill this questionnaire out.
Yes.
Well, I can't get to Mom. Daddy won't let me take Mom out of the house. So essentially what I have to do is I have to go to the court and file for that temporary guardianship if indeed I feel like Mom is incapacitated, and with very specific facts to our judge, and explain to them that this is a dire emergency. Mom is not, I know she's not taking her insulin. I know she's she's done this in the past before, and my stepfather is not helping anything. He's catering to this, and therefore the doctor then will order Mom to be examined. What if I bring, now Mom has been less than cooperative when she met with you. So if I were to convince Mom, Dad's out running around doing whatever he's doing, and I were to convince Mom to come with me to see you, and she went in to see you, and I said, okay, I want you to fill this out, Dr. Kennedy. What then do you, can you still give me this information? I would base it on what I could observe from that patient on that day. And if she did refuse to go through any of my questions, I would just document that, and that's part of the task that I would have to defer to the judge, basically to say that this person, until proven otherwise, must be incapacitated because she cannot, participate in her process. But really. What if you weren't court appointed? What if you were her doctor and you have seen her for several occasions, but she's just not a real friendly person, and so you talk to her, do you tell her that you're going to be giving this information?
Definitely.
And what if she tells you no?
Well, she as an independent woman, or she with an agent? Because if she has an agent, the agent can give me that permission to do that, right?
That's true.
Is that right? But if she were independent on her own and she refused...
I don't want you to give my daughter that stuff. I don't trust my daughter anymore.
Well, it still have to do it, right? Because she's the agent.
Well, and you can terminate that agency. So she can say, I don't want her to be my agent anymore.
Wow.
And then she can terminate the agency, and then you have a problem.
That's true.
Then your client tells you no. The other thing is with our power of attorney, our power, as Ms. McMullen has pointed out very well, our medical power of attorney is a springing power of attorney. And that springing power is only effective if you can document in your file that this person is incapacitated. And so therefore, a doctor can't release information to an agent until you've documented in your file that person does not have the capacity any longer. So it's a springing medical power of attorney. One thing that I'd like to bring up quickly here is the Health Insurance Portability and Accountability Act. And what I did is, just to give you a little idea, I brought you the Texas Department of Human Services notice that has been generated in response to the HIPAA. HIPAA was enacted in August 21 of 1996 by Congress. That's also known as the Kennedy-Kassebaum bill. And for those of you that do Medicaid planning, that was the granny goes to jail law. The Congress did repeal that portion of it, but they didn't repeal the portion that required certain standards for privacy. In HIPAA, Congress directed the Department of Health and Human Services to issue rules to govern the protection of individually identifiable health information. And while the Texas Department of Human Services notice of your keeping of privacy, to keep your medical information private, is not the universal statement for every medical entity or healthcare entity, I thought it was very interesting in going through and in pretty simple language explaining to you what they will and will not do, although there's a lot omitted from the TDHS notice. The rules were promulgated by the Health and Human Services, and the Bush administration reaffirmed those rules. There's a number of subsections in the HIPAA, such as the standards for privacy of individual identifiable health information and the rule on security and electronic signature standards. The privacy of individually identifiable health information had a deadline of April 14th, 2003. And so there was a scurrying around the first few months of this year, trying to decide just what HIPAA requires of individuals. And one of the problems that has arisen is the Texas medical power of attorney, and the fact that this medical power of attorney is a springing power of attorney. And as you all know, as attorneys, when clients come to visit you, most often they come with their children, and their children will sit in on client consultations to some extent, and in some cases, in every situation, the children will sit there, and it's often to reinforce for mom or dad what we talk about. They'll go home and, what did she say? You know, I don't remember what she said. And so having children in a client conference is not at all unusual, and I'm sure that when children come and visit with doctors with their mom or their dad, often they'll come in the room so that they can find out, because I'll tell you, my mom says, well, I got to take this medicine. Why? Well, I said I had to take the medicine. Well, what's it for? I don't know. They just said take the medicine. And so you want to find out what's going on, so you go with your parents to the doctor. Well, with a medical power of attorney, the child calls the doctor back, couldn't make the doctor's visit. Mom went to the doctor, so mom has given doctor the medical power of attorney, and it's in Dr. Kennedy's file. So child calls Dr. Kennedy and says, Dr. Kennedy, I need to know this. Well, Dr. Kennedy has not documented in her file that mom is incompetent or incapacitated. Mom has still got capacity. So there's no release. I'm sorry, Ms. Sitchler, there's no release in the file. I can't I can't even tell you your mother's my patient. I mean, it's very, very strict. And so, well, you've always talked to me, Dr. Kennedy. Well, I'm sorry, I'm not going to talk to you now. And so, one of the concerns that's going around right now, right on the listserv, the probate listserv, in fact, is a concern about how we as attorneys can draft documents for our clients that are going to comply with HIPAA. And I tried looking at the medical power of attorney and maybe inserting language in there saying that this not only covers my agent to when I'm incapacitated, but this is broadening the medical power of attorney, and my doctors shall release information to my agent. Can't do that because, one, that I don't think you can. The medical power of attorney is a document that says it must be in substantially the form in which the legislators wrote it. So you can't be getting real creative as an attorney and expanding on these things. There is a line, there are a couple of lines on there for you to make limitations to this power. But we're not limiting the power, we're broadening the power. So I don't think that we can be expanding on the medical power of attorney. There's been some discussion about putting this in a statutory durable power of attorney, giving your agent for business purposes under the statutory durable power of attorney the ability to communicate with the physician on medical issues and giving the doctor the release in this document. However, this again is a statutory power of attorney. As we know, it does not have to be in substantially the form that's in the statute. We can get real creative with this and put all kinds of things in this document. I tend to agree again with Ms. McMullen, who I think is probably the world's best attorney. Is I think a separate document saying this is in reference to the Health Insurance Portability and Accountability Act, and I give this person full authority and release my physicians from any accountability under the Act and release information to this person. We don't have those out there right now. What are we going to do right now? I'm going to suggest to the doctors that when you meet with your patients, tell them there's a new law and it's going to cause some problems. If you want me to communicate with your kids, if I can document in my file that you want me to communicate with your children, I'll document it right now. And in fact, if you'll just initial right here, we'll have a writing, and that will hopefully give you enough make you comfortable enough, because I know doctors don't want to be dealing with any more paperwork than they need to.
Right.
But you also have to protect yourself in the event there's a claim that you're violating the standards of HIPAA. On the other hand, we as attorneys need to be talking to our clients about this and either incorporating it in our statutory durable power of attorney or in an independent document. And I don't know if you're having a slump right now, send out a bunch of letters. And you may have a lot more business going on, chunking out these HIPAA releases, but nonetheless, I think it's very important for our clients, because the kids are going to get really angry with Mrs. Kennedy, Dr. Kennedy, I'm sorry, with Dr. Kennedy. And they're going to be saying, wait a minute, you were talking to me before, why are you not talking to me now? So I think this is an issue that is very, very important that we need to address right now. Let's assume we have a guardianship, and we've talked about faxing this letter over to Dr. Kennedy. So now that we have this release, you're going to be helpful and responsive. But tell me, I know that you and I have discussed this. You got this over a fax machine at one point. What would you as a physician like to see when we as attorneys are faxing these questionnaires over to you and saying, please return this to me no later than this afternoon at 4 o'clock?
That really did happen, by the way. Well, again, just to have that chance to talk with the patient and to have them know that this is even going on, really.
So you would like to have a little more than 3 hours notice?
Definitely.
And you maybe a little cover letter to explain where we're coming from.
Yes.
And saying who I represent. And I know that, to be honest with you, I'm on the phone with the daughter and she says, look, just send this over the doc, it's okay. So I just put it on the little fax cover sheet. This is in reference to Mrs. Jones. Please fill this out and return it to me as soon as possible. I've been guilty of it too. And I think that we as attorneys need to keep in mind that physicians are very ethical, and they're going to be keeping that physician-patient confidentiality very carefully.
Well, and also, even if a patient has an agent, say the son is always deferring, I mean the patient's always deferring to the son for, major questions, I still think it's important for that patient to know that this is something that we're going to put into her chart as far as her capacity, and also have the chance to answer questions that are specific to what they're asking. I mean, sometimes it's obvious that they can't drive, they don't need that chance, but they do need the chance to, decide where they'll live, or, what type of checks they could write as far as the limit on their account and that type of thing. And these aren't questions that come up in an average doctor's visit. And and so oftentimes when you get this letter with these questions on it, I can honestly say I don't know. I don't know if the patient has the ability to write a check. She probably does, or maybe in other words, maybe not probably, but if she does, and she's all deferred that over to the son, that doesn't mean that she can't. So these are all capacity issues that I think should be basically specifically addressed on an office visit, rather than just shoot from the hip and go, well, she's 90, she's bound to be incapacitated, which I think is what a lot of docs have done in the past. Oh, she can't see, she can't hear, she can't drive, she must be incapacitated, And I think that was the spirit behind people just signing those letters, which seems to be a disservice to the patient.
Now I'm going to jump over real quickly now that you mentioned that. And in the portion of the involuntary commitment paper, which is going to be back at about page, starting with page 11 and going several pages, this is in reference to involuntary commitments, but I suspect that you could even make an analogy to guardianship issues, but I've listed here some case law and commentaries in these next pages, and one of the things on page 12 is physician liability. And Dr. Kennedy brought out, that's why I'm jumping over here real quickly, is Dr. Kennedy brought out an interesting point, is in this case, the Lanier case, this was for an involuntary commitment, and the physicians filled out certificates for the involuntary commitment but never saw the patient. And the patient sued, and the doctors were held liable for fraud. And so I think it is important, although in this instance, this is an involuntary commitment, and it's a specific examination that's supposed to take place, and so it is specific to that situation. I think that it is important, as Dr. Kennedy says, to if you're going to be answering those questions truthfully, the physicians need to have some basis for answering those questions, so that there's no liability down the pike. Getting back to our scenario, so we've I've gotten, let's say Dr. Kennedy has given me a physician's letter. She's filled this out. She saw my mom, and I've gone in to have a guardianship. And as you all know, all of the attorneys that are here, this is a guardianship. I'm going to be presenting the doctor's letter at the hearing. An attorney ad litem will be appointed for my mother if my mother, and that attorney ad litem will be her advocate. And then if she says, well, I know what you're trying to do, you're just trying to boss me around and tell me what to do, and mom forgot all of the things that she was complaining about before. And so now this attorney says, do you want your daughter to be your guardian? Absolutely not. I don't want her to be my guardian. She's just trying to steal all my money. She never has liked my husband. I see Kelly over here. That's my client. That's my client. But essentially, then as attorneys, we will have to litigate this issue to determine whether or not mom has capacity. Is daughter the appropriate person to be named mom's guardian, or is husband the appropriate person to be named mom's guardian? And so I walk in, of course, as you all know, with this doctor's letter, and I submit it, and Kelly is the attorney ad litem for mom, and mom does not want me to be, our daughter to be her guardian, so I submit this letter to the judge, and Kelly says, I object, Your Honor, because that's hearsay, and so we're going to have to subpoena Dr. Kennedy, or ask Dr. Kennedy to attend, so that we can have you on the stand and under oath, so that I can cross-examine you, and the attorney for the proposed ward, the attorney ad litem, can cross-examine you. And of course, in some instances, we may even have a guardian ad litem appointed. When Kelly says, this lady really needs a guardian, but I can't say, Your Honor, she really needs a guardian, and there's a lot of issues here, but we need another person in here to kind of help. And so then, Ms. Birch over here is appointed the guardian, or Ms. Whitten is appointed the guardian ad litem to act as mom or dad. Come in and say, I always analogize the guardian ad litem is like mom or dad. I'm going to tell you what's in your best interest, and I don't care how much you scream and holler. We're doing this because we love you. And so then that guardian ad litem is going to go in and evaluate the situation, and the guardian ad litem does not necessarily have to be an attorney. It can be one of the other people who has some maybe medical background, and report back to the doctor and the judge, and explain to the judge, Your Honor, this person really does need a guardian. And so, in the alternative, though, what happens when we have a client who is like your patient, who comes in and is not taking her meds, and she's not taking her medications, and her daughter has brought her into your office, and she's disoriented. And she's and that she needs some insulin, and she's refusing to take her insulin. Is she a danger to herself in this situation?
I would say yes. Because she could die.
What if she's incapacitated? Should we wait and have? She still may need a guardianship, but she's a danger to herself. And so maybe getting an involuntary commitment is something that we need to do, and holding her there in your office for a little while until we can have her examined and determine whether or not we need to do an involuntary commitment. And one of the things that I was doing whenever I was going through this, I know something about guardianships, but I didn't know a whole lot about involuntary commitments. And I realized that there are three types of an involuntary commitment. And that's one of the things I try to do in this paper. So beginning on page 3, 4, actually 4 is where the 3 basic methods of involuntarily committing an individual. And it was really an eye-opener for me to work through this with Karen Hogan and Stacy January. It's nice to do it over tacos at Mexican Manhattan, but we went through this, and it's really pretty interesting, the interplay between these things, because you may need an emergency apprehension and detention. Now, I have emergency detention on there, but as Stacy pointed out to me, she refers to it as an emergency apprehension and detention. And this can be with or without a warrant. So when daughter goes to the house to pick up mom, to pick her up, and she notices that mom's pill bottle that she had refilled yesterday is empty. And she says, "What have you done?" "Well, you told me to take my pills." "I didn't tell you to take all the pills."
Right.
"Well, you told me to take the pills. And I just don't want to go on. Everything is terrible and the world is terrible," and you call 911. And you can have a warrantless emergency detention where a policeman will come out and pick our 911, you call 911 along with the police, they'll come out and pick up mom and take her to a mental health facility where she will be examined. She will be examined by a psychiatrist, and a physician will then have to examine mom and set out some very particular details. And on page 5 and 6 of the paper, I show the findings that the physician must state. And essentially, while they're holding mom, or while mom's being examined, you've got to, the physician must find that the person is mentally ill, a substantial risk of a serious harm to herself or others, that the risk is imminent, that an emergency detention is the least restrictive means, and there's further information, a description of the mental illness, more specificity that has to be in this report. And so as physicians, the physicians again are going to want to be very careful about what they put into this certificate. Now, this is not going to come to your office, is that right?
Right.
This is going to go to a mental health facility.
Right. Well, and actually it might be, in other words, if her insulin and that regimen has caused this crisis, she might end up in the acute care facility first with the idea that she has that, she's basically on a locked sort of ward type thing so that she can't leave, but then she still would be in an acute care facility to monitor the insulin and that type of thing. Once that's stabilized, she would basically, depending on the judge's assessment, I guess, would have her then go into a mental health facility. I guess that's my understanding. I haven't had that many experiences with that, but I think they would have her in an acute care facility first if it were a medical problem that brought her that imminent danger.
If they've overdosed on their pills, you call 911 and they'll go to the emergency room.
At the emergency room.
So they're going to be in a different situation where you don't have to do, like you can ED them or do some other things, but they're not going to go to like a mental health facility and wait around.
Right. No, you're right.
Right.
Yeah, they'd be dead here for
But the psychiatrist would come to the acute, to the acute care.
Like
So.
University Hospital, they might go to the emergency mental health.
Or they can
Right,
go up
if
to
you have
the
them.
organ. Depends on the ER physician.
Right. Yeah.
And so, fortunately, we have a lot of real experts in this area. Thank you. No, we're going to take them to the mental health facility and let them wait around till 4 o'clock the next day to see if they're going to make it. No. But essentially, there is this emergency detention that with a warrant, you can go to the crisis center at the Center for Healthcare Services and make a report for this, and the center will then issue fill out the paperwork that is necessary, This is during working hours to go to the Center for Healthcare Services. If there is not, these people don't usually wait for working hours. Usually daughter comes home from work at 5 or 6 o'clock in the afternoon, sees that mom is a little disoriented. She's saying, I don't want to do this anymore. This is not worth it anymore. And her pills are all still there. But she's just saying that I just don't think that I can stand another day of this. And you're worried about mom. You think that, well, maybe she does need, maybe she's off of her meds, maybe these are new meds are not working well. And so what you can do is you can call the Center for Healthcare Services. They have a deputy mobile outreach team, the DMOT, DMOT, which is on duty 24/7. And by the way, their phone number is 227-4357. And within about an hour, they will hopefully send out someone, a healthcare person, to evaluate your mom and see if indeed this person does need some emergency treatment, and then transport that person to a facility where they'll be examined by a psychiatrist. So you have your emergency detention whenever you're detaining that person in an emergency situation. A second way is to have a court-ordered mental health services. That's a second commitment or emergency procedure. After an emergency detention and upon an application, the court can order inpatient or even outpatient mental health services. So when you have that emergency detention and the physician thinks, okay, this person is really having a problem, then you're going to send that person, the facility will generate this application, and it will go to the court, and a judge then must appoint an attorney ad litem to represent this person, and must also at that time set a hearing, and this hearing must be held within 72 hours. But you can't hold that person in this facility until the court has determined that person is incapacitated. So at the same time that you're holding, it's going to be the next day. I see Kelly over there going, no.
It's not incapacitated. They were dangerous.
Danger to self or others. Thank you for catching that. They're danger to themselves or others. And so what we do have then is an order for protective custody so that we can hold that person, hold them over until the court can have a hearing. So essentially what we have is we'll have this person detained. They'll be examined by a physician, but this physician will be at a healthcare facility. If it's an emergency situation, as Karen says, it's probably at the university hospital or somewhere where they've gotten their stomach pumped, and or on the other hand, if they are dangerous to themselves or others but they haven't taken the bottle of pills, then it's going to be in a psychiatric facility, maybe SASH or the next one of those facilities, and they will be examined, and if an application needs to be filed, then an order for protective custody will be entered to hold them until the hearing can be held 72 hours later. And at that hearing, the court will determine whether or not they should be involuntarily committed for up to 14 days for inpatient treatment, or there could be outpatient treatment. And then there are other hearings after that. But essentially, if mom is in the nursing home, hitting at people, refusing to take medications, refusing to cooperate, screaming out at 3 in the morning, totally disrupting everybody, it may require, rather than, and a guardianship is not appropriate, it may require, at that point at least, require to have her involuntarily committed so that her medications can be administered. Also, the if she refuses medications in an involuntary commitment, she can do that unless the court enters a separate order ordering administration of psychoactive drugs. Thank you.
Can't your guardian allow the administration of those drugs?
Absolutely, your guardian can do that, but if you have to wait for a guardianship to do that and mom is acting out, we can go ahead and get the treatment, and then a guardian can be appointed. We can file an application for guardianship. In some counties, temporary guardianships simply don't happen. And in Bexar County, you can get a temporary guardianship if the necessity arises. But if we're at 3 o'clock in the morning and or we're at 10 o'clock at night and mom's refusing her meds, you can go the next morning, of course, and ask the court for temporary guardianship, and a temporary guardian can order psychoactive meds. But you're not going, with a temporary guardianship, mom's not a danger to herself or others. Mm-hmm. So that's why it wouldn't necessarily be appropriate to do an involuntary commitment if mom is only screaming out and not taking her meds and not in a diabetic coma.
Can I just clarify for a minute?
Absolutely.
Okay, because this is actually coming up in this case, and that is that there is a temporary guardianship established. The woman is in a nursing home. She is refusing anti-anxiety medication, and my stance was you can't force somebody to take Ativan or Xanax, for that matter. And the daughter basically said, make her take it. So my question is, I mean, in other words, I understand if you're in a psych facility, you can strap them down and give them an intramuscular shot of Haldol. Seems rather, right? But I don't know, I mean, legally, can you actually, you know, what does that indicate? I mean, in other words, if somebody's adamantly refusing,
You put it in their ice
she
cream.
will not take it. And what if she...
You can put it in food, but you can't make them swallow it.
Well, and that's the whole thing. Like this lady refuses to...
You can't force somebody to actually swallow.
Right.
You can, honey. Give it a shot.
So,
Give it a shot.
You can give it a shot.
even in a nursing home, when it's just a temporary guardian.
If exists and the guardian has the power to approve administration of medication, then the guardian can authorize the doctor any legitimate format to get the medication into the body, whether it's injectables. And like Kelly says, you can't force someone to swallow that's going to cause them to choke.
Right,
But
right.
you can do, part of the problem with a lot of the medications, you're limited in what you can administer intramuscular.
Right.
So that limits that you might have better medication, but you can't get that one, and you have to rely on the ones that are injectable.
And remember, then you cannot commit them if you're the temporary guardian unless you have the homicide and suicide facts to report on that application involuntarily.
Okay.
Now there's a third prong on the danger to self, danger to others, and
Substantial likelihood of deteriorating.
that's right. Thank you. Substantial likelihood of deteriorating, so that you are a danger to yourself or others. There is a case, though, in that situation that says that you have to, that substantial likelihood has to create a dangerous situation. And so we're back, it's almost as if it's a catch-22. You've got to be a danger to yourself or others before you are so bad that you're a danger. I mean, it's just circular. And so it almost makes that third prong ineffective. And in fact, in some jurisdictions, judges will ignore that third prong, and the only involuntary commitment will be given is if you're found to be a danger to yourself or others.
With that third prong, it's very hard to get the second medical certificate. You can get the first doctor to say to do the straight commitment, and an attorney ad litem will be appointed in 30 days. You can have a hearing, but you still have to have a second certificate, and nobody's ordered them to go to another psych doctor. So the problem is the second certificate. Unless they just want it.
Unless they just want it. So now we have a situation where we have an involuntary commitment, and the person is getting treated. But can we have can we have a guardianship as well as is that person incapacitated, as well as being a danger to themselves or others? And certainly, I'd like to defer back to Dr. Kennedy. Because there's some interesting facts about people that have strokes that I think are real important for us, especially as attorney ad litem. Dr. Kennedy has some information about the kind of stroke that this lady suffered.
Yes. It's a very interesting area. The thalamus is basically in the prefrontal cortex, which is, the cortical part of the brain is the thinking and the executive functioning part of the brain, but it's all tied in as a circuit in several areas beyond the cortex where you may have had a stroke actually are manifest as executive dysfunction, which is what this lady has, even though it's not in what we consider the frontal lobe, which is the executive area of the brain. And so it's basically what they call a silent stroke, because to look at this lady, she absolutely has no problem. She doesn't have a hemiparesis, she doesn't have a speech deficit, her gait is completely normal. So until you tease out these issues of memory and language and executive functioning, you really don't know that she's had a stroke until you tease out these areas. So it's basically just an area that's very much of a challenge, because oftentimes these people can carry on conversations and they can function in their normal setting if they've been in that same house for 50 years and they've lived with the same man for 28 years or 30, whatever, and they have their certain comfort zone, and maybe even if you followed them for that period of time, they may be able to remember your name and everything else. But I think the main thing I've learned as far as this case is that you have to really dig and tease out the issues. People invariably get an MRI these days anyway, so you'll have that, in their background. But if someone has just come into your office off the street and they swear they've never had any history before, it's really amazing to realize that, once you dig into those questions, that they really don't have that ability to think on their own independently. So that's really the main thing.
And some questions, if I were appointed the attorney ad litem, I'm representing mom, and I were to come in a guardianship situation, or I'd say, she responds to me. She tells me I haven't taken my meds. I do that when I want to. If I want to die, I want to die. And a person has a constitutional right to make that choice, to refuse medication and to refuse food if they don't want to eat. And so she's telling me, I don't want to do this. And she seems to be, she has a little short-term memory loss, but she seems to be very rational to me. Dr. Kennedy, why should I think that she's incapacitated?
Well, I guess that's where you tease out the judgment and the insight into that area of questioning, because, in other words, if you think about the development of the brain, basically a 6-year-old will say, well, I'm too sick to go to school. I'm going to die if you make me go to school. So as opposed to a 12-year-old whose brain has developed into the problem-solving areas where they understand that if they don't go to school, they're not going to learn anything. So, you have to tease out, it's actually kind of a judgment call on the part of the physician to say, does this person really understand what they're saying? Is this temper tantrum, at the level of a 6-year-old who doesn't understand that not taking their insulin is really going to cause them to die? Or is it really a person who perhaps for whatever reason feels that their quality of life is such that they don't have the desire to take their medicine because it makes them feel bad or whatever? But I think the main thing that I have tried to tease out is the judgment, and can they express to you in a logical way their rationale for not doing what we would consider standard of care? Does that make sense? As far as the approach. And if they just say, well, I don't want to be here because I want to be home. You know, that's, in my mind, that's not logical. You know, you want to be home, but you're not able to tell me that when you're at home that you're going to be okay, that you're going to thrive at home. And so that's where it's missing. In other words, it's like they're telling you one thing, but they can't follow it sequentially. In fact, that's where her frustration came in. She just kept saying, quit asking me these questions, I just want to go home. So that was, in my mind, that's from the stroke. It's such that she doesn't see past that. It's kind of a concrete thinking kind of thing where she doesn't see past just getting home. She doesn't care if she dies, or she says she doesn't, because she is so hooked on getting home that she doesn't care what happens when she gets there. But that, in my mind, is a judgment error, basically.
And so as an attorney ad litem, being mom's advocate, I'm seeing that mom looks really, she's going to do really well, or I can probably kind of help her through this hearing, and she may do a pretty good job, but maybe a guardian ad litem is an appropriate person so that guardian ad litem can flesh out these issues, because I'm seeing that, you know, this lady to the layman looks pretty good. Yeah. But essentially, she's got some definite medical problems. Probably is incapacitated. May be able to make some decisions about. Yes. Of course, she's going to say, "I don't want to live here." So right. That's maybe not where we want, what we want to do. But she can. She has some capacity, but overall, she has some major capacity issues because of the result of the stroke.
Of the stroke. And again, she sees either my way or the highway kind of thing. In other words, she doesn't even understand compromise. In other words, you know, on the one hand you say nursing home in San Antonio, on the other hand you say home, but what about in the middle? How about a nursing home closer to home? And she will not even entertain that. And I would say she cannot entertain that because it's just one way or the other, and she, you know what I mean, there's not that ability to engage in conversation, and I do believe it's from the stroke, basically. And so, as opposed to someone that was able to elaborate, that says, you know what, I've been in that home 50 years, I've been married to my husband all this time, we're happy there, and if we can't thrive at home, you know, even though we give it our best shot, well, so be it, you know. But she could say, I understand my symptoms. In other words, she could not explain to me her symptoms of diabetes. So, you know, but if she could say, I'm going to check my sugar 4 times a day, I'm going to call my doctor if this and that, you know, someone who has a plan, that even if that plan doesn't work out, at least they've explained to you what they can do. And she's not able to do that. She's not even able to tell me what she would do, or in other words, what are the symptoms of a high sugar? She could not tell me. Symptoms of a low sugar, couldn't tell me. So this is not a person who has that ability. I think she is not just being adamantly against taking care of herself, it's that she cannot. She cannot take care of herself. And the twist there is that, according to the daughter, and again this is all hearsay, but they say that she's been non-compliant all these years in sort of a self-destructive sort of mode. So in other words, that predates the stroke, but then you have to say, well, you know, again, that kind of compounds the self-destruction, but that makes it even less likely that she'll ever be able to have good judgment. It's sort of bad judgment compounding bad judgment.
So essentially, as an attorney ad litem, or even the attorney representing the daughter, I'm going to try to document my file and maybe work a little closer with the information that I'm receiving from the doctor. And again, overcoming the HIPAA requirements or restrictions, we may be doing more court-ordered examinations because of HIPAA if the doctors don't have the releases that they feel necessary to release this information. Just like to point out a couple of cases that I ran across that were fairly interesting. An incompetent person cannot consent to a voluntary commitment. I know that one of the situations that I came across was an elderly lady who became very loud at the nursing home. Is there ever an appropriate time to become loud? But she would become loud at night when people are trying to sleep and disruptive. and disoriented, and the nursing home was threatening to kick her out. And so we said, well, let's see if we can work with this, and let's see if maybe she's not doing well with her medications. We can work this out. And we were going to try to get her into the psychiatric hospital. And the doctor suggested that we tried to have her sign herself in so that she could be treated immediately. Because when you are involuntarily committed, there is not treatment. Now, you can be stabilized, but treatment doesn't occur until you're actually, during that detention period, until you're actually involuntarily committed. And so there's a little gap, and it could be hours or days there. But if you sign yourself into a facility, you're immediately evaluated, and treatment begins immediately. And so we thought, okay, well, we'll just do that. And she did. I mean, her son came and met her at the doctor or at the admissions office, and she didn't have a clue what was going on. But he said, sign this paper, and she signed her name. And went in, and she was treated, which is, and it resulted in there was a good outcome for this. However, I'll tell you, an incompetent person generally cannot consent to voluntary commitment, and in fact, this is a United States Supreme Court case. And it's actually on page 11 and 12, and Justice Blackmun wrote that, persons who are mentally ill and capable of giving informed consent to admission, who are incapable of giving consent, may not meet the standards for involuntary commitment. And so if you put that person in there, and they don't have the capacity to sign the releases, but you start treating them, they may not be a danger to themselves or others. They may not meet that standard, and so therefore you're confining a person, and that's an unconstitutional confinement. Additionally, assuming that he would have met the statutory requirements, he would have had an attorney appointed for him who would have advocated for him, and possibly there would have been a different type of treatment, and he was denied the ability to have an advocate on his part. So that's something to keep in mind. And we talked about the physician liability. The court in Texas, because this is a statutory creation, this involuntary commitment, and we're taking away a person's constitutional rights to walk out of the hospital whenever they want to, the courts are going to have to follow the statutory requirements very closely and satisfy every statutory requirement. And there are a couple of cases in that situation. And in fact, there was one case where a person was involuntarily committed because he refused to take medications. This probably would have been a more appropriate situation if the person was incapacitated. Then they could have had a guardian appointed for them, and the guardian could have, like Kelly pointed out, you try the ice cream, you try the juice, and you try intermuscular. But in this case, GH was interviewed by the police, and she was taken into custody. And the psychiatrist who filed her certificate said that she wasn't a danger to herself or others, but she refused to take her medication. And if she refused to take her medication, then she would become, she would deteriorate. And the court said that the evidence didn't sustain the statutory burden. Ineffective counsel. That's always important for us to know, is if you're appointed as the attorney ad litem on page 16, there's a case in the best interest of protection of HW. You're on the pages turning.
Yeah, really.
Where there was an allegation that the attorney representing the client was not effective. and the court held that there's a certain a standard that you've got, the two-pronged test that you've got to go through. If you're going to see if the attorney fell below the standard of reasonableness, and the burden of proof is on the person alleging that the attorney was not fell below the standard, and also, but for the poor performance, there would have been a different outcome. And so it's a pretty high standard to show ineffective counsel, but you'd hate to have to defend that. Finally, one of the interesting cases I came across is on page 17, Rent v. State, where a husband thought he would show his wife. He called and he said that she was weird, she had a history of violence, and he was afraid of her. And she just refused to accept reality. And so she was picked up and she was held for examination, examined by 2 psychiatrists, and she was released by 4 o'clock the next day. And she was not a happy camper, and so she went to the district attorney, and subsequently he was convicted of an unwarranted health commitment and sentenced to 2 years in the county jail. So you don't want your clients to be getting angry and trying to involuntarily commit somebody. You know, get mad at your husband, but just don't call the sheriff and say he's crazy as a loon, get him out of here. And so that's something you want to be careful about. Colleen, Dr. Kennedy and I are putting this together because we're trying to work toward a course of study where we have attorneys and we have physicians talking to each other, communicating with each other. It was so funny whenever Dr. Kennedy first told me. She came to dinner one evening and she said, "You wouldn't believe what I got in the fax today." And I said, "What?" And she said, "Somebody just faxed me over this questionnaire about a guardianship and wanted me to respond to it." I said, "Yeah." and you did, right? And she said, "No." And as we talked, it occurred to me, you know what? I wonder how many times I've done that to the doctor and not even thought in my mind. It didn't even occur to me. This is just something that, well, you're going to do and send back to me. And I know that there have been on occasions when I've been working with the doctors when I get a call from a physician or from a family. Well, the doctor said we have to have a guardianship. Well, why? Well, I said, do you have medical powers of attorney? Well, yes, but he said we have to have a guardianship. And the doctors are making these determinations, these legal determinations, and if a doctor says, I mean, that's what it's going to happen. I mean, that's like my mom.
Gospel, right?
She said.
Right.
And so we're hoping to open up these lines of communication between physicians and between attorneys and have this dialogue. Does anybody have any suggestions, or other than having Kelly do all of the involuntary commitment? Does anyone have any comments or suggestions about the information? What I tried to put together for everyone is just sort of a little something you could pull out and look at. If you, what is that statute, or where would we go, or what could we do? What number should I call? Yes, ma'am.
Isn't there any kind of a loophole or something where the medical doctors, you have somebody who cannot consent to medical treatment? I've seen this over and over. This person is so incapacitated with Alzheimer's or whatever it is, be able to save that person's life with this medical opinion letter, because you already know.
Yes, when it's that obvious. Yes, but it's the gray zone. You know, that's where you have the trouble. But I believe so. Yeah, I mean, as long as they have that agent that has, you know, taken over their care. In other words, if they have severe Alzheimer's, they've been in the nursing home for years, that the daughter has done all the medical decision making up to that point, and she's obviously incapacitated, then you basically, from HIPAA's perspective, you go with the agent's request.
And how do you feel about the doctors charging to fill out this letter?
Ooh. That's a good question.
How do you feel?
At this point, I don't charge for forms, but I've often wanted to because they're a pain, you know. But no, it's actually, I don't know how I feel about it, because you are putting your reputation on the line, you're adding liability to that person's care by stating that you think, you know, and you know, this certain opinion, and people would challenge, people may haul me into court and have me testify, and I can't charge for that either, you know. So you charge for a form, you know, or not, and I don't know if you can charge for the time you would spend to testify. I don't know.
Dr. Backer being a personal witness to this capacity, the legal point of view for that charge, because I won't pay for it.
Well, go ahead and talk to us about that. Why won't you pay for that?
I feel that you're a witness to the incapacity. You have personal knowledge.
True.
And so when I get that bill for $45, which I see a lot, I always say, I call the doctor, I send a nice little letter, and I say, well, if you don't want to fill this out, then what I'll do is I'll subpoena you to court for 4 hours,
and then have
you make $66 every 7 minutes,
right,
and I'm going to call you last,
right.
And so this is on a slam dunk incapacity issue.
Oh, right.
This is not a gray area like our 63-year-old.
Right.
But
no.
Again, I noticed in your medical letter, I didn't see a medical memorandum here either. So, you know, the question always is with these physicians, are you going to tell a person before you fill it out? Even if they are incapacitated, you've been treating them, and they are severe Alzheimer's, and you've been prescribing to them, and there is no medical power of attorney. So.
And I think what Kelly is saying, she's putting you on the spot, but what Kelly is saying is that as attorneys, and when we're having a hearing, and you're the treating physician, we have the ability to subpoena you. Right. And you don't get paid for
I agree. I hear you.
And so as an accommodation, the law has come in and said, look, you know, we don't want to be hauling docs in out of their office. And so if they'll just sign this letter, we will admit it unless there is an objection of hearsay to the letter. And so so it's an accommodation, and it's saving you the time of being subpoenaed for coming in. But knowing how busy their schedules are, I can see that they didn't think through the process.
Well, and look at the trend. In other words, I mean, I do geriatrics. I'd say at this point maybe 80% of my patients are of that age. You know, to what end do we spend our day filling these things out? Just at the whim of the family who wants to establish this, you know? And so, I mean, the paperwork is inordinate, just in any practice. And so we're basically working pro bono for all these things that, again, we may still be called in, you know? And so this is a form that you, again, if it's easy and, you know, a non-issue as far as their severity, that's easy. But these questions that tease out, you know, their ability in different areas, should they be able to vote, should they be able to drive, should they be able to handle their bank account? These are questions that I'm not just going to say yes, no, yes, no, yes, no, you know? So,
Is this the fire alarm?
I don't know.
This is what I call the gong. Is it time for
What is that?
Okay. Well, I want to just.
What is that?
I just want to say one other comment. And now that
You want
this? One of the things in reference to what Kelly said, I usually do pay the $45, and I talk to my clients, and I said, look, you know, this doctor's asking us for this $45. It's not a huge amount of money. We don't necessarily have to pay it, but we also don't necessarily want to make the doctor mad and uncooperative. And so, do you think that it's something that's okay for us to pay? And I explained to them that we don't have to pay it. Now it's all going off.
I guess it is. My
How many
goodness.
college degrees do we have in this room?
Sounds like a college.
Then we think we want to pay you back.
Pardon? And again, it hasn't come up.
Using the legal process. I won't pay the $45.
They're wandering into someone else's room and laying down in someone else's bed and, you know, eating someone else's food and that type. They are disruption. They're not a danger. but it's disruptive to the staff, disruptive to the other person or the other clients there in the nursing home, and also very disruptive to the family. So all I can say from my own personal experience is what I've done is basically I will give Ativan, I will give it as a liquid, and I say put it in the ice cream, put it in the applesauce. And on the one hand, it seems a little, tricky, if you will, but again, you do that with a child that's misbehaving, and this is the level of that person who doesn't have the ability to know that this is in their best interest to have them be calm.
You can do that with a senile patient or the
Yes.
Alzheimer's or whatever, but we have in our community the bipolar and the schizophrenics,
Yes,
don't
yes,
we?
yes.
Okay, and it just breaks your heart
Yes.
because with medication, these people could have a taste of a normal life.
Yes.
Brilliant.
Yes, but the problem is too, and again, it's considered assaultive if you do force that on that person.
I know.
And part of their illness is lack of insight. So you're hitting a brick wall, and it's just one of those sad situations, but I don't see any way around it. In other words, you can, I think part of the answer is trust. In other words, establishing trust with a physician who lets them know that this is something that's good for them. Because otherwise, again, that's part of the schizophrenics certainly have no trust as far as a rule. But if you can establish a long-term relationship and that physician can be a key person and say, you know what, this is just going to help you tremendously. And then, but oftentimes, with a 5-minute office visit, the patient's in and out and they don't hear the fact that the person's not taking it because they feel they're impotent on it. Or there's some other side effect that they are not willing to take it for that reason. So I think adjusting certain medicines and having a rapport is part of the answer to that difficult question.
I think it's a legal deficiency, a legally created roadblock rather than medical. I think the medical people could help us around it, but the constitutional lawyers,
What do you do if you can't get this person to see a doctor? They won't leave the house.
Oh, for the manic depressive or the schizophrenic?
Paranoid schizophrenic.
That's
Will they need a third prong test, and are you in a jurisdiction where the third prong will
Well,
be?
they're here in San Antonio,
and not the way that third prong is so.
You can't get the second certificate.
You can't get, it's not a real danger. The only danger is it's the tremendous loss of quality.
well, and
It's
not only
significant.
that, but it's a suspicion that this particular individual that's shown around has cancer.
Wow.
All right, and cannot get this person to go see a physician.
Well, one of the ways around that I have found is that because families have called me before and said, this lady, for example, again, severely demented, she refused to go to the doctor. I said, if you can't bring Mohammed to the mountain, I went and did a home visit. And long and short of that whole story is she's taken her risperidol and she's much more cooperative with caretakers, etc. So the first time she almost threw me out because she knew I was a doc kind of thing. Second time she was happy as can be to see me. So that's a situation where you look at it creatively. There's nothing wrong with doing a home visit as far as her. In other words, it may not. If you know she has cancer and that's not being treated, that may never be treated. But she could be treated for pain and that type of thing if a doc's willing to do a home visit. You see what I mean? And that's part of the solution. These are all very complicated problems.
FYI, that medical patients, if they're in some kind of psychological treatment where they're in a group and they're getting ongoing support with their families, they're much more likely to adhere to the medication. So it doesn't have to be just, the doctor and the lawyer, but there's, you're not going to make somebody better with psychotherapy, but you can help them live a better life.
Don't you think that changes if you add 5% dementia onto a regular bipolar that will drive you crazy? Don't you think that all that changes and that then you can do something for quality of life for cancer, get them out of the house? Then it becomes guardianship.
Yeah, that's true.
Whereas just mental illness by itself is allowed.
Exactly. Yes, that's true. That person has that autonomy. Yeah. It's very true.
Can I ask a question about the orders on guardianship? Are we putting specific stuff in them about HIPAA? Are we going to ask right in the line item in the orders about giving the guardian specific?
I think that the guardian, under HIPAA, they talk about the persons authorized, and I think guardians are one of the persons authorized under HIPAA to get information. But I don't, I mean, why, if you want to put...
If you're an attorney ad litem or if you're a guardian ad litem, it might be wise to put some HIPAA language. But the other thing in HIPAA, you know, on that handout that Patty had, under a court order or a judicial proceeding, you know, like if you're an ad litem or something like that. But, you know, we've had some problems about, I'm amazed at the 10 years I've been doing this, how many doctors will give me information and never say anything about patient privacy until HIPAA. And I was at a training not too long ago, and the thing is that the Office of Civil Rights has to prosecute any violation. Severely demented people are probably not going to contact the Office of Civil Rights,
But they might.
of the Department of Justice. Now, so I think that the big hoopla is kind of an overreaction versus what the real potential to have to pay a fine.
Yes, that's true.
You know, it's going to be, it's like the real egregious things. There was a case where a superintendent of a state school in an article mentioned a patient's name in a state school, and advocacy sued on behalf of that particular patient, and the superintendent personally had to pay about a $10,000 fine under state law. And you can have greater protections under state law than HIPAA. So you need to know your state law and your HIPAA too.
Okay, second question or follow-up. Because I listen to PPR also. On my statements now, I started adding a notary thing because everybody said, okay, is everybody else doing that?
I will say something about that. If you want to introduce an affidavit as evidence and to support an appellate record, you need to put an acknowledgement so that it is a true affidavit, because it is in a non-evidentiary form.
I understand that, but doctors don't have notaries in their offices.
I'm sorry, but I think that's something we're going to have to fix.
It used to be the law. We used to have it notarized. And subsequently, the law was changed to allow for a non-notarized document.
If it's a really contested case, obviously get it notarized or subpoena the doctor. If it's slam dunk, you may not have to worry about it unless you think you're going to get an appeal. You know?
See, I just won't. I try to look at things in a practical manner, and I tried before a number of years ago when we had to have them notarized, and I finally started sending runners over who were notaries to do it, which is an additional expense, but the docs don't have notaries in their office, and we go for weeks without being able to get this. They never objected, by the way. The reason I was so surprised when Dr. Kennedy came in and said, "Can you believe?" and I said, I've never had a doctor refuse to do it. The only complaint I ever got was the fact that I don't have a notary. Well, that's not a problem. I'll send a notary over. And we got it notarized. So I've never had a doctor give me say I won't fill one out, and they always send it back, fill it out, send it back. Now, they may not send that one back. They may say, I will put into words what I feel comfortable with, and I said, fine. Put into words whatever you want to say. And I submit that. But I quit doing the notary simply because I couldn't get doctors to cooperate with me if it had to be notarized. And like I said, the law was changed. It was my understanding that there was actually addressed, and that you no longer needed a notarized statement to offer in the.
You can't defeat a motion for summary judgment just with an unnotarized doctor's letter. So that's
Sure, but again, you've got, I guess
my concern is that, I've practice both sides of this, we all do, and if I'm the ad litem and I've got one of these that's signed but not notarized, and I'm worried about getting dinged on incompetent representation, I'm like, well, you know, this is nothing, we're not gonna proceed on this thing. So I don't want to slow down my doctor either, and I'm willing to pay the doctor, because if I take them in as a client, somebody's paying and they can pay the doctor too, okay, that's fine. But I don't want to be down to the courthouse and not get my order. So that's what I was kind of worried about.
That's interesting.
We need to, you know, if we do, so.
Cheryl?
And I forget who has done a series of this, but is it Gardner, Santiampo, or whatever, but has done a lot of CLE on contested guardianships, and when you really need to raise certain things, certain objections, and when you don't have to. Right. So for example, most of us, whether we're invited or not, pass the 10-day hearing because we want to have 2 trials. It's not in anybody's interest. Right. It's also possible that you are an attorney ad litem and your client has said, no way, Jose, and you say, yes, and I can object to this doctor, okay, on the basis of hearsay or lack of undermining or whatever. But if I think, as an ad litem, that that person is going to be harmed by the doctor angry, showing up and testifying strongly and adamantly, I think I can advise my client just like I advise any other client. I wouldn't push this. Go ahead and let that come in. Let's angle it from a different direction. I think that we do our client a service, not ineffective assistance of counsel. Instead, I will defend you, Karen, if you decide to weigh the and that's a quote.
And let's remember what the true defense of guardianship is. It's a functional analysis of this person's ability, regardless of what that doctor says. I can go above and beyond that letter, right? When the doctor has not given me enough, and I see doctors a lot of times say they can choose their own residence. All I have to do is put that probably incapacitated person on the stand, and I bet you I can show they cannot choose their own residence. Right. A lot of treating psychiatrists are very concerned about at least personal happiness. And they're happy living there, but they will ignore that they go out in the winter without a shirt, they don't know their address, they're having cash in the house, and very unsafe things happening around them. So remember that the functional analysis of what's going on here is the true defense to that medical letter. So you put your proposed ward on the stand, and you have them count change, and you talk about what medicines are you want. And I think the true ethical question is that attorney ad litem going to prep that client so much that they will mimic instead of truly respond? And I believe that there are hired guns everywhere in the world that are attorneys, and that they will do this to try to win instead of doing a protection, which is what guardianship is about. And I also believe the attorney ad litem at that point should be using the guardian ad litem. There are some ethics that are so soft on this end, and some that are not enforced, that if you go in and you say, objection, medical Miranda rights were given here, and blah, 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 and try to make that a $20,000 trial when you have an Alzheimer's victim rocking a baby doll, I think that is incapacity on the attorney ad litem's point. And I think I would never use that attorney ad litem again, and I would trash their reputation in any guardianship trial I was ever in. So you have to have a balance on that. But I think training the attorney ad litem on knowing how to defend is something that is very rare. You know, we're talking about how to pursue today and how to defend these things legitimately and without creating malpractice, because I have pride in what I do, and I do nothing but guardianships. I am proud when I defend, and I know how to defend without creating malpractice. And I help my ad litems do the same thing. If you need your moment in court, I don't care if you just peed all over the judge's floor. I'm going to give you your moment in court, but I may not need to have to bring that doctor in. Because I asked my client, what are you contesting here? And like Cheryl said, I don't want a lot of harm. So I think you can balance this. And I think that's the part of the legal that never gets addressed. I'm just like paying the doctor for their opinion.
Yeah, we know where you come from, Kelly.
For Dr. Kennedy, your $45 is very cheap compared to other objects.
It is $45.
They also electricity.
Thank you all for I know how